There are 9 of them. They are appointed for life, answerable to no election, removable by nobody short of a constitutional crisis, and the decisions they make from a marble building in Washington, D.C. can, and do, reshape the daily lives of 330 million people. The question nobody really asks is, what does it cost to become one of them? You did not plan this career. Nobody plans this career. You cannot put Supreme Court justice on a college application the way you might put doctor or lawyer, because the path there is so specific, so long, so dependent on the intersection of talent and timing and politics and sheer fortune that planning it is essentially meaningless. What you can do is become the kind of person that path eventually finds. This is your life at every level as a Supreme Court justice. Level 1. You are 22 years old, and you are in a constitutional law class on a Tuesday morning, and the professor asks a question that has technically already been answered by the Supreme Court in 1803, but which, in a room of 23 first-year law students, produces 12 completely different answers. You give the 13th. The professor pauses. She says, "Interesting. Not right. Not wrong. Interesting." And you spend the next 3 years chasing that specific word from every professor who teaches every class you attend. Because interesting is the thing that sets apart the people who practice law from the people who eventually shape it. Law school is, simultaneously, the most intellectually exhilarating and the most professionally brutal experience you have had in your life. You are surrounded by people who are exactly as smart as you, and you discover very quickly that smart alone is not the differentiator you always assumed it was. The differentiator, it turns out, is clarity. The ability to take a genuinely complicated question, strip out everything that is emotionally satisfying but legally irrelevant, and arrive at an answer that is logically defensible even when it is not comfortable. You are exceptionally good at this. You graduate in the top 3 of your class. You get the call from a federal appellate judge who wants to discuss a clerkship. You do not know yet that this phone call is the first step on a path that has no exit ramp. Level 2. A Supreme Court clerkship is the most competitive legal position in the country. Not most prestigious. Most competitive. There are 4 of them per justice, 36 total, and the pool of applicants is every top graduate of every top law school in America, all of whom are roughly equally credentialed, all of whom want this with the specific intensity of people who have been building toward it for 3 years. You get one. You spend a year inside the building that the rest of your career will be spent trying to get back into. You read every brief. You write every bench memo. You sit in the chamber and watch oral arguments from the best seat in any courtroom in the world, close enough to see the expressions on the faces of the 9 people who will decide what the Constitution means on this particular Tuesday. You learn something in this year that law school could not teach you. The justices are people, smart people, often brilliant people, people with deep, genuinely held convictions about what the law requires and what the Constitution means. But people. They have good days and difficult mornings and the specific exhaustion that comes from carrying decisions of enormous consequence across a career that, by design, has no end date. You file this away. You will spend the next 20 years thinking about it. Level 3. You practice law. Not immediately in front of the Supreme Court. That comes later. For the very few, in the very specific cases that rise through the system like lottery numbers, improbable and specific, and shaped by circumstances no one entirely controls. You start in federal litigation. You are the kind of lawyer who gets pulled into the cases that matter. Constitutional questions, civil rights arguments, federal statutory interpretation, the ones where winning or losing has consequences that extend far past the client sitting across the table. You are very good at this, not because you are aggressive, because you are clear. You write briefs that judges find unusually useful, which is the highest possible compliment in federal court and which means almost nothing at a dinner party. You argue your first case before a federal circuit court at 31. You win, not triumphantly, narrowly. On a 2-to-1 split that a dissenting judge finds entirely unpersuasive and says so in writing, which becomes the most useful piece of professional criticism you have ever received, because it forces you to understand not just why you were right, but exactly why a reasonable, intelligent person found your argument insufficient. That understanding is the thing that eventually makes you a judge rather than just a lawyer. Level 4. A federal judgeship is its own kind of arrival and its own kind of trap. You are appointed, not elected. The distinction matters in ways that take years to fully understand. You are answerable to the law, to the Constitution, to precedent, but not to the voters in your district who may find your decisions uncomfortable, inconvenient, or actively contrary to what they believe the Constitution should say. This is the design. This is also the argument. You sit on the federal bench for several years, writing opinions that are read by people who will use them as ammunition in arguments you did not anticipate, applied to cases you could not have predicted, shaping outcomes in specific, real, consequential ways for specific, real, consequential people. You develop a judicial philosophy, or rather, you discover the one you already had. Because what a federal judgeship teaches you, more than anything, is that the law is not a machine that produces correct answers if you input the correct facts. It is a framework built on values, and the values of the person applying it are not separable from the outcomes it produces, no matter how carefully any judge pretends otherwise. You write an opinion in a case involving a constitutional question that, to your mild surprise, gets discussed in law journals. A former colleague emails you. The subject line says, "They noticed." Level 5. Your name appears on a list, not publicly, at first. Internally, within the White House counsel's office, in a document that is theoretically confidential and practically impossible to keep that way for more than 72 hours before it is being discussed in newspapers. Your name appears on a list. This sounds like an honor. It is also the moment your life stops being entirely yours. Journalists call people you went to law school with. They pull every opinion you have ever written, every speech you have ever given, every law review article you published when you were 26, and had not yet understood that everything you write in your 20s will eventually be read back to you in a room designed to make you uncomfortable. The White House counsel's office calls you. They want a meeting. You drive to Washington and you walk into a building where people are very polite and extremely direct simultaneously, which is its own specific Washington skill set. And they explain what the process involves. You already know what the process involves. You have been watching it your entire career. You say yes anyway, because you have spent 30 years becoming the person this job requires, and the alternative, stepping back now for reasons of comfort or caution, is simply not a sentence you are able to finish. Level 6. The Senate Judiciary Committee hearing is not a job interview. You understand this going in. Your preparation team explains it patiently and in detail, but even after all the preparation in the world, nothing fully replicates the experience of sitting at a single table in a large room while an entire country watches, and having your entire life, every case, every speech, every opinion, everything you wrote when you were 26, used as either a weapon or a shield, depending entirely on which side of the dais the senator using it sits on. Senators on one side of the aisle quote your opinions approvingly and describe you as a brilliant legal mind. Senators on the other side quote the exact same opinions disapprovingly and describe you as a dangerous ideologue. The opinions did not change. You answer each question with the specific formulation that your preparation team drilled into you for weeks. I cannot comment on matters that may come before the court. This is legally appropriate. It is constitutionally sound. It is also, from a public communication standpoint, uniquely unsatisfying to absolutely everyone watching. You do not flinch, not because you are not human, because you have spent 30 years developing the specific kind of clarity that allows you to sit in an uncomfortable situation and be entirely present in it without being destabilized by it. The vote is 51 to 49. You are confirmed. You go home and sit in your kitchen for 20 minutes before anyone arrives to celebrate. You are not entirely sure what you are feeling. You are entirely sure it is permanent. Level 7. The robe is heavier than you expected, not literally. It is fabric. The weight is something else entirely. The accumulated weight of every person who has worn this specific garment in this specific building and made decisions that people are still arguing about, still citing, still living inside the consequences of decades and sometimes centuries later. You are sworn in. You sit on the bench for the first time, in the chair that has your name on a small placard that nobody outside this building will ever see. The attorneys below begin their argument, and something shifts, not dramatically, not with the ceremony you might have expected after 30 years of building toward this moment. The shift is quieter than that. It is the specific, settling recognition that you are no longer arguing about what the law should be. You are deciding what it is. The difference is larger than it sounds. Arguments can be made in any direction. Positions can be advocated passionately from either side. A lawyer can believe something fully and argue its opposite because the client requires it. A justice cannot. What you decide in this chair, in this building, is what the Constitution means on the specific question before you. That is either the most terrifying or the most profound thing you have ever been responsible for. It is, in your experience, both. Level 8, the case arrives. Every justice serves for years before it does. Some never get one. Some get several. The landmark, the case that produces a decision so significant that it becomes a cultural and legal touchstone, taught in every law school, cited in every related case for generations, is not guaranteed by the position. You get one. The case is complicated in the way that the cases that reach the Supreme Court always are, because the simple ones are resolved before they get here. This one involves a constitutional question on which the lower courts have split, on which legal scholars genuinely disagree, and on which the American public has a strong, divided, emotionally charged opinion that the law is technically not supposed to care about, but which exists as a constant background frequency in a room where everyone is human, and pretending otherwise requires specific effort. You deliberate, you discuss, you read and reread. You write the majority opinion. It takes 4 months. When it is released, the reaction is immediate and total. Half of America describes it as a triumph of constitutional principle. The other half describes it as a betrayal of constitutional principle. Both halves are reading the same document. You go for a walk. You think about the first-year law student on a Tuesday morning who gave the 13th answer to a question the professor had already seen 12 wrong versions of. You think about the professor who said, "Interesting." You think about everything between that classroom and this. You come back to the building. Level 9. Not every decision is yours. You write the dissent in a case where you are in the minority, and the act of writing it teaches you something that 30 years of legal career did not entirely prepare you for. A dissent is, structurally, a letter to the future. You are not writing for today's majority. You are writing for a future court that you will not serve on, making an argument you believe the law requires that the current court has declined to adopt, with the specific and unsentimental understanding that you may be right and the majority may also be right, and the law may contain both of those possibilities simultaneously in a way that is deeply uncomfortable for anyone who wants legal questions to have single, clean, permanent answers. You write it clearly. You write it without bitterness, which takes more discipline than it sounds. You write it for the law student who will read it 40 years from now in a constitutional law class on a Tuesday morning and give an answer that the professor calls interesting. You file it. You go back to work. Level 10. There is no retirement in the conventional sense. You serve until you choose not to, or until you cannot. And the question of when that is, at what point the institution requires something your body or mind can no longer reliably provide, is one of the genuinely difficult ones, because the incentives to stay are so profound and the consequences of leaving at the wrong moment so significant that even the most self-aware person in this chair has difficulty making the decision with complete objectivity. You think about your legacy. Every justice does, even the ones who say they do not. Not in a vain way. In the way that any person who has spent a lifetime doing consequential work thinks about whether the consequences were, on balance, what they hoped they would be. Your name is on opinions that shaped things. Some of those shapings you are proud of. Some of them, with the benefit of time and distance, you would write differently. Both of those things are true about every justice who ever served. You sit in the chair. The attorneys below begin their argument on a new case. You listen. You decide. That is the job. That has always been the job. Every Supreme Court justice starts the same way. A question in a classroom that does not have a clean answer. The difference between the people who practice law and the people who eventually shape it is not intelligence, though intelligence is necessary. It is the willingness to sit in the specific discomfort of a question that has no comfortable answer, hold it clearly and honestly, and decide. That willingness, across 30 years of cases and clerkships and opinions and confirmation hearings and landmark decisions, is how 9 people who nobody elected end up deciding what America is. Subscribe. Tell me which level hit different. Drop the next topic below.